All right, diving right in. Today we're tackling how agreements actually work, legally speaking, in India. We've got these study notes on business laws and ethics,
Yeah, from the ICAI.
right? The Institute of Cost Accountants of India. So goal is to pull out the core of what makes a contract actually stand up in court under the Indian Contract Act, the one from way back in 1872.
Right. And not just like, is there a contract, but when do things go sideways? Void agreements, that sort of thing.
Exactly. This is like your cheat sheet for anyone listening who's ever going to sign anything, personal business, whatever.
Exactly.
Okay, so first things first. What even is a contract in India, legally speaking?
Well, if you go right to the source, the Act, Section 2 lays it out. A contract is an agreement that can be enforced by the law.
Okay, so just agreeing to something isn't enough. It's got to have that legal backing.
Right. And then Section 10 comes in and gives us the whole checklist. What makes that agreement actually enforceable?
Hit me with a checklist.
So first, you've got to have offer and acceptance. Someone proposes something, and the other person clearly agrees to it. That's Section 2A and 2B, defining those terms specifically.
Like, hey, I'll sell you this for X rupees, and the other person's like, deal.
Exactly. And that offer and acceptance got to be communicated properly. Section 4 talks about that. And Section 5 gets into how you can revoke an offer or acceptance, before it's too late.
Right, right. So there are rules even around backing out of a potential deal.
Absolutely. Now, one thing that trips people up is that the acceptance has to be absolute and unqualified. No ifs, ands, or buts. Like, imagine I offer to sell you my car for a certain price, and you say, I'll take it, but only if you throw in a new set of tires. That's not a contract yet. You've introduced a new condition. It's a counteroffer.
Makes sense. Got to be a clean yes.
Yep. Then there's the intention to create legal relations. Like, are we actually serious about this being legally binding, or are we just chatting?
Right. So friends making a casual agreement to meet for dinner, probably not a contract.
Probably not, no. And then there's the big one, lawful consideration. It's the something for something in the agreement. Section 2 defines it as an act, abstinence, or promise.
Hold on. Abstinence.
Yeah, like if I say, I'll pay you 1,000 rupees if you don't smoke for a month, you're not smoking is the consideration.
Wow. Okay. So it's not always about money changing hands. It's about something of value being exchanged.
You got it. And a fascinating thing about consideration is that it doesn't even have to come from the person making the promise. There's this landmark case, Chenaya v. Ramaya, which established that a third party can provide the consideration.
So if my uncle promises to pay you to mow my lawn, that's still a valid contract. Wild.
Yep, perfectly valid. Now, we can't forget about competent parties. Section 11 is very clear on who can't enter into contracts.
Yeah, like kids, right.
Minors, exactly.
Oh.
And folks of unsound mind and people specifically disqualified by law for certain reasons.
Okay, so let's break this down a bit. Minors, I get. But what counts as unsound mind when making a deal?
Good question. Section 12 talks about being able to understand the contract and form a rational judgment about it. It's not just about having a mental illness. It's about your capacity at the time of the agreement. Like, imagine someone having a temporary episode due to high fever or intoxication. That could make the contract voidable.
Interesting. So context matters.
Absolutely. And then you've got all those folks who might be disqualified for other reasons. Alien enemies during wartime, insolvents, convicts. Even companies can be disqualified if they're trying to do something beyond what their own rules allow.
Makes sense. Got to stay within the lines. Okay, so back to our checklist for a valid contract. We've got offer, acceptance, intention, consideration, competent parties. What else?
Ah, yes, free consent. This is huge. Everyone involved has to agree without any coercion, undue influence, or deception. You can't be forced or tricked into a contract.
Right, so no holding a gun to someone's head to get them to sign.
Definitely not. Then, the object of the agreement, the purpose itself, has to be lawful. Can't have a contract for something illegal or against public policy.
Makes sense. No contracts for, smuggling endangered animals.
Exactly. And lastly, the terms of the agreement gotta be certain and possible to perform. No vague promises or agreements to do something impossible.
Right, so like you said earlier, no selling them in.
Precisely.
All right, so that's our checklist for a solid contract. But you mentioned things going wrong. What's the difference between a void agreement and a voidable one?
So a void agreement, Section 2G, is basically a dud. It's not legally enforceable at all. It's like it never existed.
Okay, and what makes an agreement void?
Many things. Like, If the consideration or the object of the agreement is unlawful, that's a straight-up void agreement under Section 24.
Like a contract to sell stolen goods, right?
Bingo. And generally speaking, agreements without any consideration are also void, Section 25, though there are some specific exceptions to that rule.
We'll get to those exceptions in a minute. What else makes an agreement void?
Well, if the agreement is in restraint of marriage, like preventing someone from getting married, that's void under Section 26.
Wow, really? So even if two people agreed to not marry, that wouldn't hold up in court.
Not in India, no. And then there's restraint of trade, Section 27. You can't unreasonably restrict someone's right to carry out their profession or business.
So I couldn't, like, make you sign something saying you'll never teach contract law again.
Not unless it was part of a very specific and reasonable agreement, like if you were buying my entire legal practice and didn't want competition. There's an exception for sale of goodwill.
Right, that makes sense.
And then there's restraint of legal proceedings, Section 28. You can't entirely prevent someone from going to court, although arbitration agreements are a common and valid exception.
So a clause in a contract saying you can never sue us, that'd be void.
Pretty much, yeah. And then you've got agreements that are void for uncertainty, Section 29. If the terms are too vague, it's not a contract.
Makes sense. Got to be clear about what you're agreeing to.
Right. And finally, wagering agreements, Section 30, those are void too. Basically, agreements that are just bets or gambles.
So I couldn't take you to court if I lost a bet to you?
Nope. Those types of agreements are unenforceable. Now, a voidable contract, that's Section 2I, is different.
Right. You said it is valid, but one party can back out.
Exactly. And that's usually because there was something fishy about the consent. Maybe there was coercion or undue influence involved.
Okay, so coercion I get, but what's undue influence?
It's a bit trickier. It's where one party has a position of power or influence over the other, and they use that to unfairly pressure them into agreeing to something. Like imagine an elderly person being pressured into signing over their property to a caregiver they rely on.
Ah, so it's about an imbalance of power and taking advantage of someone's vulnerability.
Precisely.
Okay, so void is like it never happened and voidable is like it happened, but it can be undone.
You got it.
You mentioned exceptions to the no consideration, no contract rule earlier. What are those?
Ah, yes. Section 25 actually lists a few key ones. Like, if an agreement is based on natural love and affection between close relatives, it can be valid even without consideration, but it has to be in writing and registered.
Okay, so like a parent gifting something to their child.
Exactly.
Yeah.
And if you promise to compensate someone for something they've already done for you voluntarily, or something you were legally obligated to do anyway, that promise can be enforceable even without new consideration.
Interesting. So if I promised to pay you for helping me move last month, even though we didn't agree on a price beforehand, that could still be a contract.
It could, yes. And then there's the promise to pay a time-barred debt.
Time barred.
Yeah, it means you owed the money, but too much time has passed for the creditor to legally sue you for it. But if you make a written promise to pay that old debt anyway, that promise can actually revive the debt and make it enforceable again.
Wow, that's good to know.
The big takeaway here is that while consideration is generally a must-have for a valid contract, there are some very specific situations where the law makes exceptions.
All right, so to wrap this all up for everyone listening, remind me again, what are the absolute essentials of a valid contract in India?
Okay, so you need offer and acceptance, the intention to create legal relations, lawful consideration, competent parties, free consent, lawful object, certainty of terms, and the possibility of performance.
Got it. And we learned that certain agreements are automatically void, meaning they're not legally enforceable at all.
Right. And others can be voidable, meaning one party can choose to cancel them, often because of issues with consent.
And while consideration that something for something is usually a must, there are some interesting exceptions. Plus, not everyone is legally allowed to enter into contracts.
Precisely.
So next time you're signing anything, think back to this deep dive. Does your agreement tick all the boxes? Are there any red flags that could make it void or voidable? It's not just legal jargon. It's knowledge that can actually protect you in real-life situations. Thanks for listening.
Thanks for having me.
And hey, if this deep dive left you with more questions, especially about those exceptions to the consideration rule, well, there's a rabbit hole to go down.